All right, Mr. Lamb, you can call your next witness.
Your Honor, the state calls Agent Samantha Poague.
All right, Agent Ford.
Swear the testimony you give in this case will be the truth, so help you God?
Yes, I do.
Have a seat. I sent it. Will you check with Miles? Sorry, Judge, I'd moved so much stuff around over here, and I was looking for some documents that I was waiting for somebody to bring me from across the street, but I will go without them for the moment. All right. What's your name?
Samantha Poague.
Where are you employed?
I'm a special agent with the Georgia Bureau of Investigation out of the Americus office here in Sumter County, Georgia.
And how long have you been employed by the GBI?
For 9 years.
As a special agent, what's your job in a general sense? I mean, your generalized job duties.
Investigate crime, anything from theft all the way up to murder.
How does the GBI get involved in an investigation, at least typically?
Typically, we're a request agency, so chief of police, sheriff's office, district attorney's office, somebody like that request us to help with a crime. In this particular case, I got requested by the Georgia Southwestern University campus police.
And when you were requested to become involved in this, when was that?
January 14th, 2024, approximately 2 p.m. in the afternoon.
As part of your investigation, did you at some point obtain information Did you obtain information from various telephones, various cell phones?
Yes, I did.
And whose phones did you seize or obtain by request?
I obtained 2 separate phones from Julian Williams. I obtained a cellular phone from Trinity Poague, and I also gained access and consent to get Paris Permort's phone.
So the phone that you seized from Trinity Poague, or that you got from Trinity Poague, how did you get it?
During the interview that I conducted with Ms. Poague on the January 14th, we were discussing some videos during my interview that she was showing me in her phone. And at that point, I realized there was evidence in her phone, so I seized it.
And did you subsequently get a search warrant to permit you to, or permit the GBI to access the contents of the phone?
Yes, I did.
And after you got the search warrant for the phone, did someone in fact access the phone?
Yes, sir, we did.
Okay, how do you do that?
So we have a device, it's a digital extraction device, and what it does is essentially makes a copy of all the information in the phone at that time and just makes an entire copy of it. And it doesn't do anything to the device other than copying the information. And so it stores it in a unreadable format, basically. And then you have to create a reader report or like a PDF report or something to be able to access the information inside the phone. You know, kind of make it easier for you to follow along and read and find information.
Did you, when you accessed the defendant's phone, Ms. Poague's phone, were you able to extract any text messages or instant messages that had been sent between Ms. Poague and Mr. Williams?
Yes, I was.
Speaking of, is Trinity Poague in the courtroom?
Yes, she is.
Okay, can you kind of identify for us where she is and which individual she is in the courtroom?
Yes, she's sitting at the defense table. She's the middle female in the olive green shirt.
Okay, and you know her not only from result of this investigation, but I mean you have met with her personally and questioned her or interviewed her, filled out an arrest report, went through that whole process, the arrest process, et cetera, with her. Is that right?
Yes, that's correct.
Okay. All right. So, and this is the same person you got the phone from?
Yes, sir, it is.
Okay. All right. So, when you access those messages from Ms. Poague to Mr. Williams, one of those messages, well, let me ask you, I'll do it this way. What's States 41? What is that document?
These are messages that were pulled out of, I believe it was Instagram, possibly Facebook. There were a couple of similar social media accounts that had similar names, and off the top of my head, I can't remember exactly which one. But these are messages that are not text messages from cell phone number to cell phone number, but in another format on social media. But this is one from Trinity to Julian, or Jay.
All right.
On
what's the date and time of it?
December 17th, 2023, and it is, let's see, I'm looking at the time difference. The only reason I'm looking at the time difference is because it's in UTC time. May I explain that real quick?
Yeah, I was just ask you to do that in a moment anyway, so that's fine. You can go ahead and do that now.
So UTC time is Coordinated Universal Time. It is the time that is whatever time it is at 0 degrees longitude, like the prime meridian, and it establishes a time for the entire world. And then like Eastern Standard Time would be -5 hours from that. So you would just subtract 5 off of what UTC time is to get the time, what it is right now. Like March to November, when the time changes, it would be -4, if that makes sense.
Okay. All right, so UTC time, why do these different reports, these various data sources, computers, phones, et cetera, why do they use UTC time? Do you know?
Well, it's a standard time because it's not, this device that we use, this program, is not only here in Georgia, it's worldwide. So that's their standard to put it in UTC time, because crime doesn't only happen in Georgia, it happens everywhere, and phones change times and all of that. So it keeps it standardized, and then you can change it to whatever time zone you're in, just to make it easier for you.
Right, so you subtract some hours for Eastern Standard Time, you add some hours for time in Asia or other places.
That's correct.
Okay, all right. So you were trying to do the math and subtract 5 from that
Yes, sir.
timestamp?
Yes, sir.
Can you tell me now what time that message was sent?
It looks to be around 11:24 p.m.
Okay.
So that would put it on the 10th, December the
And
10th.
December the 10th.
Yes, sir.
Okay. And what does that message say?
You want me to read it?
Yes, please.
Jay, I don't know if I can do this anymore. This weekend was a struggle for me, and I don't know what to do. I love you so much, but letting JD hit the wall and see the damage it did really hurt me, and it just lets me know that I don't have JD's best interest at heart. You should not be with a girl that doesn't love your son. I keep trying and trying, but nothing changes. Every time I see him, I cry. I cry because he looks like you, just like you, and a part of me wishes he wasn't yours. I cry because I realize that you and someone else share something so sweet, and that's love for him. I don't know what to do, but I hope you understand where I'm coming from. Like when you called the face expression you gave me. I cannot be around him anymore. I'm sorry, I don't know where that leaves us, but I know that you will never make a decision. I want a family of my own, Jay. Every time I see him, I just want to cry. Seeing him happy and how he is with you at your house and how he is with me, he hates me, Jay. He cries nonstop with me.
Okay. All right. Now, I want to ask you to look at a different exhibit. This is from the group me messages that also were extracted from her phone. And then this is the one that just Let's show you State's Exhibit 42. And I'd like for you to tell the jury if you can identify this, and if you need to see I pulled one sheet out of a packet. If you need to see the whole packet in order to identify it, I can address it. Did I tender 41, Your Honor? I thought I did. If I didn't, I would tender State's 41.
Any objection to 41?
No objection, Your Honor.
Submitted without objection.
Give me that packet. Do you know what that's from?
Yes, sir.
Okay. What is that that you're holding?
These are some messages that I pulled out of Miss Poague's phone when I extracted the data. So when we do investigations, I'm just a piece of the investigation. You heard from crime scene earlier. I had my supervisor who was out on scene helping me do some interviews. He had done some witness interviews for me and given me information from some of the other witnesses on the hall that there was a group me message that involved several of the other students that were on the same hall as Miss Poague. And I had pulled these messages out of the group me message between some of them.
But these were messages that were on Ms. Poague's phone.
Yes, sir, that's correct.
That had been sent and in some instances received in the group me text group.
Yes,
right?
sir, that's correct.
Okay, all right. So the message that, so the sheet that you're holding, State's Exhibit 42, is that true and accurate printout of what's included, or at least that portion of what's included in the phone?
Yes, it is.
Right. Would tender State's 42.
Any objection?
No objection, Your
All
Honor.
right, submitted without objection.
There's a message on there. Let me think which one. It's the third one on that page. Okay. What's the date and time of that message?
December 10th, 2023. Let's see, that's midnight. Probably about 10:36 p.m. Well, so we back it up. So it's December 9th at about 10:36 p.m.
And that message is to a group of girls in the residence hall where she lives. Is that right?
Yes, sir, based on my understanding of reading the entire thread.
Okay. And what does that message say?
This one says, y'all, I'm sorry if you hear this baby cry. He doesn't feel good, so everything he does, he cries about it. I promise I ain't killing him.
And that message was on December the 9th, which was the night before the message saying, I'm sorry for letting him hit the wall and doing the damage it did, or whatever.
Yes, sir, that's correct.
Okay. When you were examining Ms. Poague's phone, or examining the data that was extracted from Ms. Poague's phone, did you extract some data regarding some internet searches, web searches that were performed on the phone,
Yes, I did.
okay? And when were the web searches that you were looking at, were there any from January 14th, 2024?
Yes, sir, there were several.
Okay. And can you tell the jury what time were the web searches in question?
I don't remember at this moment without referring back to some things on exactly when they started, but in a general sense,
Well, if you need to look at your report or your notes, you can do so if you have those.
yes, I do.
I
So I remember there were some that while we were still at the hospital, so just kind of a recap, I got called about 2 a.m. I don't live here in Sumter County, so it takes me a little bit of time to get over here. We were at the hospital for quite a while, and then we moved from the hospital over to America's Police Department here in town. So there were some at the hospital, and then there were some.
What time were they?
I've got some between 2:30 and 4, and then several more around 7 p.m.
Okay.
But there were also some, there were several around 2:30 p.m.
Okay. 2:30 p.m. on January 14th. Okay. All right. What were the web searches? What were the search terms that or search phrases that Ms. Poague typed into her phone during, we're talking at this moment, about the 2:30 to 4 o'clock time frame? What were the messages that she typed in?
How do you get a brain bleed? And can a depressed skull fracture go unnoticed? And then there were also some searches on how to deactivate Facebook. And then there were a couple of other searches related to infant brain bleeds.
And those occurred when you say searches related to infant brain bleeds, was infant brain bleed the search term?
I don't remember if that was exactly what it was, but I also noted that there were some that consisted of phrases, what causes infant brain damage and subarachnoid hemorrhages.
Right. And then you said there were some other web searches, Google searches, that occurred later that same day?
Yes, sir. There were some when I know to her to be, Trinity to be at the hospital, but there were some that I know that she was sitting at the police department waiting on me to be interviewed.
Great. So the 2:30 to 4 o'clock messages, those were, or not messages, but searches, those were where? Where was she when those were done?
She was at the hospital
Okay. And then the messages or the searches at 7 p.m., where were those done?
at the America's Police Department.
Okay. And what terms did those searches include?
The ones around 7, they were searching for images about and information about skull fractures.
Nothing further.
All right, cross-examination.
Agent Ford, you were the, I guess, for lack of a better term, you're the lead investigator for this particular case, correct?
Yes, sir, that's correct.
And so you would be the one in charge of trying to make sure that a thorough and correct investigation was done, correct?
Yes, sir, that's correct.
And of course, when you first got called in, you knew that there was a child that had some severe injuries that led to the death, correct?
That's correct.
And you were aware at that time that the last 2 people that you knew were in close proximity to the child would have been Trinity Poague and the father, Julian Williams, correct?
That's correct.
So naturally, in an investigation, when you first start, the way you start off, most time I think, is the people most in close proximity that might be able to explain what happened or might even be possible suspects, correct?
Generally, yes, sir.
And in addition to those two people, as you got to doing your investigation, you were able to discover as well that although Julian Williams had the child was actually living with he and his sister, Ashante Burr, correct?
Yes, sir, that's correct.
And so you also knew that, and in the investigation, if you went a little further, you were able to determine that she really cared for the child more so than Mr. Williams, correct?
I don't really think that's correct, but I think that she did have some significant time caring for the child.
And they lived in Cockwood, Georgia, I believe, correct?
Yes, sir.
And but you did know that Mr. Williams, by interviewing him and whatnot, you were aware that Mr. Williams spent a great deal of time over here at Georgia Southwestern, spending the night with Trinity Poague, correct?
That's correct.
And so each night he would be with Miss Poague would be a night, for the most part, that he was not with the child, correct?
Well, I mean, yes, sir, if he was here, he couldn't be there, so I
Well, I
can't
mean,
tell
I
you.
understand sometimes he took the child with him and they spent the night, but that wasn't all that often, correct?
I mean, I just have what they've told me. I don't know exact time frames. I know that there were several times when JD has accompanied Mr. Williams here.
Yes. But other than those times, the rest he was by himself, and that would mean that Miss Burr was left in charge, correct?
I can't tell you exactly where he was and who had him, but from what I've been told, she has been a primary caregiver, yes.
Now, and then in investigating, you interviewed Mr. Williams and Miss Poague, correct?
Yes, sir, I did.
And they were together when you first saw them at the hospital, correct?
I believe that's right.
I mean, I don't know if they were right side by side, but they were in the proximity of the hospital at the same time, correct?
Yes, sir, they were both at the hospital.
Now, when you interviewed them to begin with, did you put them in the same room and interview them then?
No, sir.
Why not?
That's not common practice for anybody to interview. When I interview people, I do my best not to interview them together, at least initially. So I try to get independent statements from people.
It'd be fair to state that the reason behind that is you want to hear what one person says and then the other and see if they match up?
Yes, sir, you want to get independent statements.
And if you put them in the room together, they tend to feed off each other and maybe you can't get a straight story, correct?
It's possible.
Depends on, I mean, sometimes they may be diametrically opposed and blame each other, but sometimes they may be together and conjure up a story together if you're asking with them there together, correct?
It's possible.
And would I be correct that GBI protocol basically would tell you that when you have that type of situation, you don't want both of them in the same room being interviewed, correct?
I wouldn't necessarily say GBI protocol. I think it's law enforcement in general. I mean, I want to do a thorough investigation. I want independent information. Interview them separately.
And so that's what your training as a law enforcement officer has taught you, correct?
And common sense, sir.
And common sense. Okay.
Yes, sir.
Very good. So you interview Mr. Williams at first, correct? Not necessarily he was the first one interviewed, but you interviewed him. I'm not trying to get a timeline of which one first, but let me just go to your first interview with Mr. Williams, okay?
Okay.
Because I believe it, and correct me if I'm wrong, but you had more than one interview with Mr. Williams, correct?
That's correct.
And your first interview, you talked to Mr. Williams about what happened. At that time, he told you that Trinity had called him on the phone, and he gathered from the phone call that there was distress with the child of some sort. She could just hear JD, or something of that nature. And he came back to the dorm room and immediately saw that the child had...
Restate your question. You're asking her what?
I'm asking about what Mr. Williams said. He's already testified, and he's present to testify again, you know.
Well, whether he's testified or not, it doesn't make that out-of-court statement not hearsay. I mean, if he wants to impeach Mr. Williams, there's a way of doing it. This isn't it.
Okay. Before we get into all of the statements, I want to address that and something else with both of you. So I'm going to let the jury step into the jury. All right. Are you planning to ask her a series of questions about what the defendant told her in an interview?
Yes.
Okay.
About what the defendant told her, or what?
I mean, what
Not the defendant.
Williams.
We're going to get to the defendant. That's why I wanted to go ahead and get the jury out. But about what Mr. Williams said, all right. So, I mean, that is a hearsay statement. there would have to be some sort of an exception, because it is a statement made by someone other than on the witness stand, if it's asserted for the truth of the matter. So, so what exception would you be operating under?
As my understanding, the witness is present to testify, then the witness can be called to testify. If that's the reason the hearsay exception exists, because you can't cross-examine a hearsay statement, you have no way to dispute it. But in this case, he's available to be able to testify, and has testified.
Okay, but I don't think that's one of the exceptions. Now, like an impeachment or an inconsistent statement, I know those would be exceptions. And there are exceptions for when the witness is available to testify and when the witness is not available to testify. These under the, Georgia got away from the, more or less has adopted the federal rules of evidence. So, for any of these statements that you ask of what the defendant, not what the defendant, what Mr. Williams said, it has to be under one of those exceptions, if I'm not mistaken. One of which would be if you asked him a question and, said, did you say this? And he denied saying that, then I think it would be a prior inconsistent statement. But otherwise, I think you've got to find one of the other exceptions. Am I wrong about that?
In my opinion, yes, Your Honor, but if that's the ruling, I accept it, I'll move forward to something else.
Okay. Now, the other question I wanted to ask you, well, I do think, I'm going to just be clear, 801C of the evidence code, 24-801C, dealing with hearsay. Hearsay means a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Doesn't matter whether he's here or not. And then there are a series of exceptions. I can't remember if that's 802 or 803 or what, but that deal with when the declarant is available. So it has to be under one of those exceptions if you ask her about any of the statements made by the witness, I think.
Under 24-803, Your Honor, those are the exceptions for when the availability of the declarant is immaterial.
Okay, and 801D is the one, a prior statement by a witness, if it's inconsistent, is admissible. Or impeachment. So I do think it has to be, under one of those exceptions if you're going to ask a series of questions about what he may have said. Now, we had this pretrial discussion about any statements that the defendant made to Officer Fort, and at this point, those statements have not been put into evidence. So, and I think the rule is unless she's going to testify, you can't ask her about those statements.
Yes.
I thought you were on that page, but I wanted to make sure before it came up in front of the jury. Okay. So I'm going to flip to 803. All right, and that is the following shall not be excluded by hearsay, even though the declarant is available as a witness, and then it has a series of those. So those are the ones that we would have to be operating on if you asked her about anything that this defendant said. Okay. Well, let's bring back in. Wait, you need a. All right. Hey. Well, I guess wait just a second. All right, Mr. Gamble.
Thank you. Agent Ford, I'm going to ask you some about the interview. I'm not going to ask you about particulars about what was said in the interview, but I do want to ask you about about the interview. You interviewed Mr. Williams on more than one occasion, correct?
Yes, sir.
And you did that all in the same day, or was there one day you did an interview and then met with him at a later time as well?
I interviewed him on the 14th, and then I want to say it was still the 14th, but it was really late, like going into the 15th. So I can't, without looking at the exact time, I know it was later that evening, and it possibly ended into the following day. And then I met with them, I don't remember if it was a week or 10 days after the incident happened. I met with him again.
So you had three, it may have been the same day for two of the interviews and then another one on a different day for 3 times.
I believe that's correct, yes, sir.
And of course, you talked to Miss Trinity Poague a few times as well, correct?
That's correct.
A couple of times that day at the hospital, and then there was another time a little later with her as well, right?
I mean, what do you mean by talk?
Well, interview. Maybe the last time there wasn't really an interview.
The first time wasn't an interview. Later at the police department, yes, sir, there was an interview. There was a second interview at the police department, and that was it.
Okay, so let me get a little bit of feel for the investigation. I know that once you had done interviews with both parties, you went to the dorm, and I believe, or you or some of your agents tried to talk with as many of the people that were at the dorm as you could to see any knowledge they might have, correct?
My supervisor was at the dorm, yes, sir, and Agent Gibson.
And some of those interviews occurred with one or the other of them?
Some people on the hall, yes, sir.
And in addition to that, as you already stated, you got the phones from both parties, correct?
Yes, sir.
And you talked to Miss Poague's roommate as well, Miss Permont, correct?
I wasn't the initial interviewer, but I did do my own interview with her, yes, sir.
So you did your own interview, and there was someone else that talked to her as well, correct?
Yeah, it was a follow-up interview.
And of course, you had your medical examiner to give you some information about the injuries and that type thing, correct?
Yes, sir. I attended the autopsy.
And of course, we've already had the crime scene specialist that's testified about going to the scene and trying to collect evidence, correct?
That's correct.
And of course, you heard him testify already, but there's no evidence that he collected from that scene that you consider to be particularly useful in trying to make a decision one way or another about this case, correct?
Define useful.
Well, was anything that he did introduce to try to prove or disprove who did this?
Well, he took some photographs, so we didn't actually have to introduce what he collected, but the receipt that shows he was at Walmart.
So you did get a little bit that kind of confirmed where he was at near the time, correct?
Well, based on what the medical examiner testified to and what he told me back then, he wasn't present.
And you did get some video of them coming in and out of the dorm area within that time period, correct?
Yes, sir, there was some video.
And you were aware from an investigation that the child came with Mr. Williams to the Americas area, but actually met Miss Poague in Albany the Saturday night before this occurred on Sunday, correct?
That's correct.
And initially, the meeting was somewhere in Albany at Chipotle, and then they went to a couple of places, and you actually got some video from that to be able to kind of prove that they did indeed go there to eat, correct?
That's correct.
So that part of what was told was true, correct?
It appears to be, yes, sir.
And then they came back to the place where Trinity lived at the Oaks around 10 o'clock, give or take a few minutes, and you know that because you had the video of them coming in for the night, correct?
That's correct.
And you also know that it was a little bit of time after that before anyone went to sleep, and at least there's been testimony that apparently Mr. Williams was the first person to go to sleep, correct?
I don't know exactly when everybody went to sleep, but at some period or another he did go to sleep, yes.
And so the time window of when Miss Poague was around the child at any time where you could consider it to be alone would have been after 10 o'clock on Saturday night until Sunday at 12 around 12 when the child was taken to the hospital, correct?
You're saying that she was only around him by herself between those hours?
Yes. Well, I mean, I understand Mr. Williams was there in the room, but he might have been asleep.
I mean, I wasn't present. Based on some statements that have been made to me, yes, she was with him at some point after 10 p.m. and had access and was around him all the way up until they left the dorm room 12:35-ish on Sunday p.m.
Okay. So you had 10 o'clock at night, that's 2 hours and 12, it's about 14 hours worth of time, give or take 30 minutes, correct?
I believe that's correct.
Now, you were investigating this particular incident at the time that you got there fairly quickly, I believe. You began to determine that you thought it involved some type of child abuse, correct?
The information provided to me was consistent with that, yes.
And so because of that, you needed to do an investigation, try to determine the who, what, where, and why involving that, correct?
Generally speaking, yes.
And in trying to make that determination, one thing that can be important in child abuse cases, a lot of times that child abuse kind of leads up to bad things happening at the end, but before that, there's a child that may be getting abused before an incident happens that leads to their death, correct?
I've seen it kind of both ways.
Right, I mean, it's not always that way. Sometimes it's a one-time thing, correct?
That's correct.
But you do know that sometimes there's a lead up, which means that you would want to try to check some background to see if that's possible, correct?
Sometimes, if special circumstances.
Well, this particular case, your own medical examiner and at least some of your doctor reports seem to indicate that they not believe all the injuries happened at the same exact time, correct?
I believe he said it's possible they occurred at different times.
Well, I mean, he said some things, I believe, didn't he, that he thought could not have happened at the same time.
I mean, are you saying at the same event? Are you saying on the same day? I don't think I'm quite understanding what you mean.
Well, in questioning him, he had said some things he thought it could have happened only in an hour or so, that only an hour window, and some he believed may have a window as much as 24 hours or 36 hours, that type thing, concerning certain injuries he saw. You recall that type of testimony?
I recall him saying they could have happened at the same time, but because you can't age bruises like that, it could have been more, but they also could have been at the same time.
Well, with those injuries, isn't it important to try to determine the history of that child to some extent, to be able to determine if the child was subject to any kind of abuse in the past?
I believe I did that, sir.
Well, I mean, you did determine, one, you got all the medical records for when the child had gone to the doctor, correct?
I did.
And those records, what did they tell you?
That he didn't have anything wrong with him. He had had some checkups, and I didn't see anything that alerted that he had anything wrong with him. But again, I'm not a medical doctor, so I can't make specific determinations about that.
You didn't see anything wrong with the fact you hadn't been to the doctor at all in almost a year?
I don't remember the time frame on that.
Your Honor, it's irrelevant, first of all, whether she observed, whether she knew that or not, and it's also irrelevant whether she thought it mattered.
It's not irrelevant, Your Honor. I'm entitled to a thorough and sifting cross-examination in determining whether or not this investigation was properly performed is tantamount.
I'll allow that question.
Thank you. You did not think that was an important issue?
I'm not going to say it's not important, but based on the immediate injuries to the child and the severity of the injuries at the time, and based on what we know is the cause of death of the child, that didn't matter. That wasn't important.
Well, you interviewed both of those parties, but did you ever go to the home where the child lived?
No, I did not.
So if you sit here today, if I wanted you to, you don't even really know the physical structure of where that child was residing before this happened, correct?
That's correct.
And you have not interviewed anyone that is connected, let's say, to Mr. Williams as far as any of his friends, have you?
His friends,
Yes.
no. Family, not friends.
You didn't, but I'll get the fabulous thing, but friends, you didn't try to find anybody you consider close to him and interview them to determine if they knew anything about his relationship with the child, did you?
That's correct.
You didn't go to his job site and meet any people he works with to ask them about it, did you?
No, I did not.
You did not ask any of the neighbors about what they may have observed around that household in the past, did you?
No, I didn't.
And the only other person, the family members you interviewed was the Shantae Burr that sometimes keeps the child, correct?
Well, she's one of the primary caregivers, so she was crucial to interview. So yes, we interviewed her.
She was crucial to interview. You asked her some about whether she was the caretaker for the child and that type thing, correct?
Another agency, but yes.
You were trying to find out background about it, but other than interviewing Miss Burr, You didn't determine, nobody tried to determine whether or not she was dating anybody, did they?
I'm sorry.
Ms.
I-
Burt?
Trying to
Yes?
determine if what?
She was dating anybody.
No, sir, her relationship status was not of concern to this investigation.
Well, if she had a boyfriend or someone she was involved with that potentially could abuse a child, wouldn't that be important to know?
Objection. It's irrelevant. There's no evidence of prior abuse. And the cause of death in this case, the undisputed testimony by every physician in this case is that this child died as a result of an injury that he had incurred within an hour.
All right, what's your response to this?
That is not the entire testimony from any of those experts. Those experts went back as far as 48 hours with some of the injuries they said could be, and that leaves in a time frame in which she could not have been the person responsible for, and if it turns out that there were injuries that occurred on a Friday or a Thursday, they could not have been her.
All right, I'm going to allow the questions. The jury will make a determination of what is or is not pertinent.
Thank you, Your Honor. You didn't, and you don't consider that to be important of what type person she might be dating as far as exposing the child?
No, sir.
Didn't feel like that was important to know?
Based on the videos and the pictures and the evidence that we have on January the 13th, 2024, the child didn't have any injuries. And then we go into the 14th, and all of a sudden he's got catastrophic injuries where he's dying. And he is taken to the hospital where he ultimately is deceased. Now, we've got videos of JD where he was fine the night before. So, no, sir, I did not think that anything that happened with Miss Burr's relationship status prior to the time when we know the injuries were sustained had anything to do with his death.
Now, when you did your first interview with Mr. Williams, you stated you did a second follow-up, correct?
Correct?
And then even a third one later on, right?
Yes, sir.
And there was a reason you did a follow-up was because you didn't believe that everything he was telling you exactly matched up with what you were investigating, correct?
Objection, Your Honor. The agent's subjective beliefs, one way or the other, or motives for conducting an interview are not relevant at all. I mean, whether she conducted an interview or, she can testify if she did or she didn't. But
I think that question asked her to give a judgment on the truthfulness of another witness. I'm not going to allow that question.
Well, when you got the second interview and the third interview, in one of those interviews when he came back, not the first one, but the follow-up ones, he came to be interviewed, he was with, his sister had brought him to the interview, correct?
Yes, sir.
And he came in to be interviewed by you because you were trying to follow up to make sure that your investigation was proper and had looked at everything before making decisions, correct?
Generally speaking.
And so you bring him in, and in that interview at some point, you begin to interview him and you're not satisfied with exactly what he's saying. So you brought Miss Burr into the interview room and interviewed them together, didn't you?
I don't believe it was like that. Ms. Burr had a video on her phone that I knew of, and I brought her into the interview so that we could get the video and ask him if that was the video he was talking about. That's what I remember.
But you were asking questions about that video, times that it occurred, when it was downloaded, when it got sent, all that type stuff, correct?
I did ask that, I believe, yes.
And that was with both of them present, correct?
We had already referenced it in prior interviews, though.
And there had been some discrepancies you were trying to hash through, correct?
Without listening to it again, if you pointed to something specific, I might could, but I don't recall that.
You will acknowledge that you're violating the rule you just told me about not having two people being interviewed at the same time, correct?
No, sir, that's not true at all.
Not true.
No, what you're saying about violating rules, I'd already gotten their independent statements.
Mm-hmm.
This was to follow up and get the video with them together. So that's not the same thing.
So is your testimony under oath today that the only purpose that you had for those two meeting together was just so you could see that video?
Objection. Her purpose in conducting an interview is irrelevant.
I'll overrule that. I'll let her answer that question.
I can't give you exactly what I was thinking at that time 2 years ago, but anytime I have somebody to interview, I'm gonna ask some follow-up questions, but I do remember specifically that video was important.
Now, you do acknowledge that the picture that we've shown earlier of the diaper that showed the diaper that Dr. Busman testified he believed had blood in it, that diaper was not available for the defense to be able to test anything from it, correct?
Correct.
And you would acknowledge that was a piece of evidence that was involved in at least and recovered from the area where the supposed crime scene occurred, correct?
I wouldn't necessarily call it evidence. I mean, it was in there with a lot of other trash. All the other trash wasn't evidence either. It's just a piece of the story.
But a piece of the story that if it could be tested, could have determined whether or not blood was in the fecal matter, correct?
I mean, I'm pretty sure we've established that you can do a test for it. However, there wasn't any blood in it.
But your expert technician that testified, he didn't believe there was any blood in it, correct?
And that's correct. I believe him.
Over Dr. Busman.
Yes, sir, I do. I've worked 9 years with Agent Gibson. We've worked numerous homicides together. He is trained by some of the best people. If he tells me there was no blood in the diaper, there was no blood in the diaper.
So no need to ever have a test for blood then, is there?
He is a bloodstain pattern analysis expert. He's looked at more blood than I can ever imagine to. If he knew there was blood in it or saw anything to be blood in it, he would have tested it. And he has a kit on him that he could do on scene if he saw blood.
I mean, he can just eyeball it. He doesn't need a test, right?
It appeared to be a dirty diaper that
It
is
definitely did prove
routine.
that. Isn't the truth of the matter is that you'd already made a rush to judgment on who was going to be responsible for this, so trying to keep the diaper didn't really matter because you'd already made a decision that Trinity was the one responsible and there was no need to do an investigation any further.
That's untrue.
So that's not the reason why you didn't follow up over in Colquitt and try to find out anything about backgrounds or anything of that nature, correct?
I wouldn't say I didn't follow up and do anything on backgrounds. I did conduct some background information.
Did you run a criminal background check on Mr. Williams?
I did.
Is that part of the case file?
It is not. We don't typically always put criminal histories in there because not everybody who has access to it is certified under GCIC.
But criminal defendant is allowed to receive all of your investigatory file of any information that involves this case, correct?
Your Honor,
Correct.
If he wants to go down this road, I think it's something that should be taken up outside the presence of the jury.
I would have a motion on that, John.
All right, is that your last question?
Yes, on that for the moment,
I
John.
don't even know if I
We'll
can
get
come
back
back.
to that. Do you have any,
Redirect, Mr. Lamb.
No redirect, Your Honor.
All right. Well, we'll let the jury step out for just a second. I'll tell you what, wait right there. Chet, are you back? Chet, are you back? Where some of the jurors want to go downstairs, but I want a bailiff to go with them if they do. Okay. All right, so y'all can step in. We'll take a 15-minute recess. You can step down.
I'm just going to put these exhibits right there. Is that?
Yeah. All right. What do either of you want to address about the criminal history of the defendant?
Yeah, I would address that I have a right to that criminal history. It's not been provided by the state. I've moved for a mistrial, but those information that is relative to this case has not been provided and has been denied the defendant, which he has a right to. And I don't know what it says, but Mr. Williams already testified. We did not have that provided to us. I could not use it for cross-examination or even determine. I don't know what it says, and I'm not directly blaming any particular person on it, but it's supposed to be provided to us. We are allowed to have it. We don't have it, and that's a Brady violation, Your Honor.
Well, I guess that depends on what's in it. If it's a Brady violation, right?
Well, I mean, I think that they're required, regardless of what it shows, to provide whether this is culpatory or it's not. If it's If it's great for the defense or it's great for the state is really sort of irrelevant. The part is whether or not it is part of the case file. Is it part of their investigation? Just like when they interview someone who says, I know nothing about the case, they still have to provide you
Okay.
with that.
What's your response, Mr. Planner?
Well, Judge, if we received it as part of a case file, then as far as I know, it was served. I'm not even sure that we have a copy of a criminal history on him. There's nothing in the statute that entitles him to a copy of the criminal history in a vacuum. I mean, of any particular person. What he's entitled to is the things that are listed in the discovery statute, which I haven't pulled up because this is not something we would normally deal with in the middle of a trial. I do know that if at any point, someone had said, hey, we don't have a copy of his criminal history, do you have one? I would have said either I don't have one or I do. If I have one, I'd give it to you. If I don't have one, I'd probably get one and for the purpose of providing it to him.
Okay.
And so it is not part of as far as I know, it's not part of my file. I don't think we have one. I don't think there's a.
She says she ran a criminal history. I don't know if that means it was printed out and put in the file or what. I guess you could ask her the question to clarify that. You want to come back up?
Did you print one? 'Cause there's no
Just so we'll make a record of it. I don't. But I do wonder, was the criminal history ever requested by the defense?
Yeah, the criminal history was not requested. We were not aware it had been run. I mean, I realize we could have tried to make some kind of, I realize you maybe could file a motion to say that, but
It's
that's
been a
just.
while, but I thought you, since this has come up, but I thought you could ask for a criminal history on any witness, of the state's witnesses. Am I dreaming that up, or is that in a,
there's a process that they can. I mean, if I have criminal histories on witnesses, then we provide them as part of discovery.
Okay.
There's a process by which they can a defense.
I thought there was a statute where it could be.
There is. There's a
Okay.
statute that provides for a defense lawyer's ability to obtain a copy of criminal history of witnesses, his witnesses, my witnesses, or any other. But that's not what. But that's not the process that's involved here. All right.
Was a criminal history printed out, ran? What did you mean by ran?
We, as agents, we don't actually run the criminal histories. We have to get a criminal intelligence analyst to run it. Mm-hmm. So they conducted a criminal history, and I do remember reading one, but it wasn't printed out. It wasn't like it was made a part of the case file as anything.
How did you read it?
They give it in a secure portal to us.
Because you read it on a computer.
Yes, sir.
Okay. All right. Do y'all have any follow-up questions about that? Okay.
No, Your Honor.
All right. But it was not made part of the case file.
No, sir. It's standard to run criminal histories on people when we go interview them, like if we're going to go to a house or talk to somebody. Safety purposes for the officer.
All right. Do you have any questions for her about that?
Well, I suppose I have a question, and that is that when there's a criminal history run, my understanding was, at least typically, I would get as part of a GBI report, I would get an exhibit, which says, provided intel information about this person or that person or whatever, and it would have attached whatever intel information was obtained. If there's no summary that says that, then does that mean you ever actually obtained the intel report? I mean,
sometimes we obtain intel just to locate somebody, or make sure that we get a driver's license photo to make sure somebody looks on their photo like they are in person and who they're pretending and portraying them to be.
When you request an intel report, isn't there typically a summary that says intel requested,
Yes.
and then whatever you receive from the intelligence agency or the intelligence department, whatever,
Yes.
that gets attached to that summary?
That's correct.
Okay. Is there any summary in this case that says that there was an intel request?
No, there's not.
Okay. So if there's not a summary saying there's an intel request, are you even certain that you did an intel request in this case?
No, sir, I'm not.
just kind of thinking that you probably would have, basically. Is that fair to say?
Yes, sir.
Okay. That's all. I don't have any further questions.
Any other questions?
Well, no, Your Honor, but trying to say that I didn't make a report, so therefore it doesn't have to be revealed, flies straight in the face of what statutorily they're required to provide to us. And,
All right.
and now him
I'm gonna
trying to
let-
rehabilitate is not effective.
Well, I'm gonna let her step back, and I'll let y'all make any more argument. You can step back down. So you're making a motion for a mistrial because of, you believe they accessed a criminal history report and you weren't provided it.
Correct, Your Honor.
All right. What's your response to that?
I don't know that there is any. He asked her, "Did you run a criminal history?" She says, "Yes." Okay, but then once you start, question a little further, it's like, well, wait a minute, maybe I actually didn't. It's just sort of I might normally would, but when it's normally done, it gets attached to a summary. I mean, there's a summary saying I ran the criminal history, or I requested an intel report, I guess is what it typically would say, and then whatever information came from intel would be attached to the summary and be provided. And so, when we get the reports, I mean, if there's no summary that says that, then there's, nothing that triggers us running a criminal history. And so I'm pretty certain that we've never seen one.
All right.
And that, and whether it is, in any event, before the court could even consider, I think before the court could consider any motion or anything related to this issue, there'd have to be some showing of whether there was prejudice, which means there'd have to be some showing that that a report did exist, that the report was in the hands at some point of the GBI or the state. It wasn't in the hands of the DA's office, but for these purposes, police agency is part of the state. And third, it would have to be established that the report in some way contained exculpatory or impeaching information, and those criteria have not been met.
All right. Well, I don't know that there was a report. There is testimony that she reviewed a report, but based upon what's before me, I'm not granting a mistrial. I guess that's something y'all can address, but the record's clear, and y'all can address it post-trial if necessary. All right. We'll be in recess for another 10 minutes. I'll come back at 11:30. Do you anticipate other witnesses?
Right now, I do not, Your Honor. I mean, there's still one witness that I have started to call 3 times this morning and changed my mind each time, and I guess I ultimately will get to the point where I have to make a decision
Well,
whether
I
I'm
guess
going
you
to
got
call
10
her or
minutes.
not. So, yes, sir.
All right. Well, if you did call that witness, would it be a lengthy witness? I'm
No,
just
sir.
trying to plan
No,
the
sir.
day.
It would not.
Okay.
It
All
would
right.
not.
So I think regardless of whether you call a witness or not, the next step for the jury is going to be a lunch break. Okay? An early lunch break.
So you're going to finish this?
Don't you think that would be a...
Yes, I don't have a whole lot. I've got a few more questions, but it won't be very long. on
Oh,
what
you
I
had
find.
more questions. I thought you...
Well, it's fine if we pick it up after lunch if you want to. I mean,
No, I want to finish this witness, but when we stopped, I asked you to finish your cross-examination, and you said you did, and then I asked if there was any redirect.
I did. I apologize. There's a
But
couple
you need
things
to ask us
I
some
do.
more
There's some
questions.
things I need to ask. Not about that, but something else. Yeah.
All right, well, we'll do that when we get back to Ms. Agent Fort. You'll need.
So we're going to start back at 11:30.
Yes, sir. All right, Mr. Gamble, you can continue your cross-examination.
Thank you. Agent Fort, would you agree with me that in your investigation, there's really no evidence of any type, what I would call instrument or weapon used that caused these injuries to the child?
No, sir, I don't think we made a determination exactly what caused that. That's right.
So you're saying it's kind of up in the air as to whether or not it was some type of instrument like a board or a paddle or something, or just someone's hands?
I believe we know that it was blunt force trauma. Blunt force trauma can be near about anything.
Correct. I mean, we've already kind of gone over that range earlier with some of the doctors, but you can have blunt force trauma from a significant high fall, like from 50 feet high, correct?
Yes, sir.
Obviously, that caused some blunt force to you, right?
Right.
Bad car wreck would cause blunt force, correct?
That's correct.
Your Honor, I'm going to object that, I mean, I don't think she's not qualified as an expert for the purpose of answering these questions. And I mean, if in fact those things have already been established by other witnesses, and they've been established by other witnesses, to ask her to comment on that at this point is essentially asking her to comment on the testimony of another witness.
Gamble. Well, if that indeed is true, then she's not qualified to say it's a blunt force injury at all, Your Honor. If that's what the state is saying, we'll accept that and move on.
Well, I don't think asking her questions about exactly what it could have been, you hadn't laid that foundation. So I will ask you to move on from that line of question.
Without going into all the potentials what blunt force could be, you do look at a body sometime in your investigation and try to determine if anything was used to cause injury to the body, correct?
Yes.
And you've been trained in that in your handlings of investigations through the Georgia Bureau of Investigation?
I have not been trained in instrument patterns, no.
So you don't really know then. So your earlier statement is you don't know what caused the blunt force injury, you just know it was blunt force injury, correct?
That's correct.
Now, did you ever at any time look at or observe the hands of Mr. Williams?
I mean, I've seen them, yes.
Did you take photographs of them?
No, sir.
Now, have you had times in the past when you had situations in which you believe someone had used their fist or hands to cause injury that you took photographs to try to see?
I have done that, yes.
But it wasn't done here, correct?
That's correct.
Now, you would agree with me, Mr. Williams is a fairly good-sized guy, correct?
I mean, that's subjective. So I can't really answer that.
You don't think that he looks sort of strong and powerful?
Again, that's subjective.
Well, from your own objective viewpoint, do you believe he could cause great injury with his bare hands if he wanted to?
Depends on who it is he's trying to cause harm to.
Could he do that to a small child?
I guess it's possible.
Now, you've heard testimony about his jacket maybe having some type of substance on it. Did you take that jacket into evidence?
I did not.
That's all the questions I have, Your Honor.
All right, any redirect.
Did you, on the day in question, on January 14th, did you see Julian Williams face to face?
Yes, I did.
Did you spend some time with him?
Yes, I did.
Where?
I might have spoken to him at the hospital briefly, but I spent, 4+ hours with him at the Americas Police Department.
And were you able to see what he was wearing?
Yes, I was.
Did you observe anything about it or that appeared to be vomit?
Yes, sir. There was some stains. I believe they were on his right shoulder and collar of a shirt.
And did you have any conversation with him about those?
I asked him about it.
Let's just say hypothetically that you decided that you wanted to take his jacket. So if you took his jacket and you wrapped it up, put it in an evidence bag, put a tag on it, and sent it to the crime lab, okay? So what would you do? You'd drop it off in the drop box in Columbus, right, for the crime lab?
That's correct.
And so you drop it off there at the crime lab, and you put some kind of a request on it when you do that.
That's right.
So the request in this case what request could you make of the crime lab with regard to testing the jacket?
There's not really a test for us to send up there and ask the lab if this is vomit on his jacket.
Have you ever submitted vomit to the crime lab for testing to determine if it was vomit?
No, sir, I haven't.
Have you ever submitted vomit to the crime lab for the purpose of determining DNA or obtaining DNA?
No, sir, I haven't.
If you sent a request to the crime lab and said, okay, we want to confirm whether this vomit came from this person. When somebody says the vomit came from that person and that person has been vomiting and they've been, in and out talking to police officers all day long, okay, would there be any value in trying to get a report that says, yes, that's vomit and it came from the person who he said it came from?
No, sir, there's no value in that.
Was there any question, like maybe 2 people vomited on his jacket that day and you're trying to determine which one of them it was?
No, sir, that was not a theory or any information relevant to this case. It never came up.
So when you make those kinds of, when you submit testing requests to the crime lab, I mean, do you do it for every item that may possibly be connected with a person in some way?
Are you asking if we send every item we collect?
You collect every item and send it to the crime lab to determine if it's connected with a particular person.
No, sir.
Would you, for instance, have sent a request to have the sippy cup tested to see if it had the baby's DNA on it?
No, sir, we wouldn't have done that.
Okay. Why? Why wouldn't you just send them everything, Agent Fort, and get, a vault full of testing on every case?
It takes considerable time to test all of this evidence, and there was nothing contrary to believe that anybody other than the baby was using the sippy cup.
So you would only ask for testing if there was an issue that was in dispute and that issue was material to the investigation in some way?
That's correct.
Okay. And who makes that initial determination as to whether or not it's material in some way?
Usually the agent's crime scene or other agents.
That's part of your job or Gibson's job or whoever, right?
Yes, sir, that's correct.
That's all.
Any other cross?
Couple, Your Honor. So Agent Gibson, the one that decided the diaper wasn't important, would be the same one that would decide about the jacket, correct?
No, that's not correct.
It would be you?
Agent Gibson was at the scene and I was interviewing Mr. Williams, so.
Now, no one has made a request for you to test that jacket from the defense side, have it?
No, sir, not
And-
that I'm aware.
But that it is kind of confusing, the issue, because no one's saying you should have tested the jacket, but if you wanted to try to prove whether or not there was vomit at all that occurred from that child, wouldn't the best way be to prove that to provide the evidence of the jacket with the vomit so it could be seen?
I'm sorry, that was a little, can you reword that?
Well, let's say if you've got the evidence here, there's some dispute or questions about whether or not the child vomited, when the child vomited, that type thing. We know that was at least raised that the child may have vomited, correct?
Correct.
And the best way to prove whether or not the child vomited would be able to provide the physical evidence of here's the jacket with the vomit on it, correct?
Theoretically, but, I mean, I guess that's possible.
So it had evidentiary value, not that it needed to be tested, but it had actual evidentiary value, did it not?
No, sir, it didn't.
Because it's not important to you to be able to prove that fact, you just want it to be whatever you say, is that right?
No, sir, that's incorrect as well.
But you didn't feel like it was important enough to save?
I mean, it's in videos, it's in pictures. We acknowledged it and we talked about it. There's multiple law enforcement who saw it. I mean, the only value it holds is the child threw up. We have somebody who testified that the child threw up. When he was at the hospital, it smelled like some sort of bodily fluid. similar to what vomit smells like. It just proves that the child threw up.
That's all the question I have, man.
All right, may this witness be excused?
She may be, Your Honor.
All right, you can step down.
Thank you, sir.
No, Judge, I got another question. I'm sorry. I apologize. I really do. I apologize. What is an intel report? I mean, in general, what is an intel report?
An intel report or intelligence request?
An intelligence request.
Typically, an intelligence request is something when we're trying to locate somebody or obtain a lot of information about somebody involved in a case, where we need their background information, driver's license, social security number to prove that's them, addresses, phone numbers, social media. Have they been involved in any cases before? Do we have any other intel requests on them in the past? Something of that nature.
Okay. And do you do an intelligence request, an intel request, on every person who's a witness in a case?
No, sir, I don't.
Do you request a criminal history on people who are witnesses in cases?
No, sir.
In fact, y'all aren't even allowed to run a criminal history for me if I say, can you run a criminal history for me if you don't have a case, right? Isn't that right?
That's correct.
I mean, you gotta have a case number in order to run a criminal history, right?
That's correct.
Okay, so it's not, running criminal histories is, are there some statutes, some laws about it?
Yes, there are.
You have to take the security and integrity certification course once every 2 years.
Yes, sir.
And if you don't have that certificate, if you don't complete that in that time, you're not even allowed to view a criminal history.
That's correct.
Can't request one.
That's correct.
The laws are pretty restricted about it, aren't they?
Yes, sir, they are.
Direct and leading, if he wants to direct, but he is feeding the witness.
I suppose
sustain that.
I am leading. I was trying to get through it quickly. Would you run a criminal history on an individual just because you were curious about him?
No, it would either be for an intelligence request or officer safety.
Nothing further.
Any other questions?
Just one or two follow-ups, yeah. But if someone is a suspect in an investigation in which you're about to charge them, may charge them, or are going to charge them, often you do run background checks then, do you not?
Sometimes.
That makes sense, doesn't it?
I mean, sometimes we do, yes, sir.
That's what I said.
All right, may this witness step down.
Yes, sir.
You can have a seat. All right, Mr. Lamb, you can call your next witness.
Your Honor, subject to confirming that all of my exhibits have been tendered and admitted by the court, the state would rest at this time.
All right. All right, ladies and gentlemen, the state has rested its case. Customarily, there are a few items we need to address before we proceed at this juncture in the trial. So and it's 11:45, so I'm going to go ahead and let you take your break to lunch. I'm going to ask that you return to the jury room at 1:10.